I'm Wade Henderson. I'm president of the Leadership Conference on Civil and Human Rights and the Leadership Conference Education Fund. I'm also the Joseph L. Rao Jr. Professor of Public Interest Law here at the University of the District of Columbia's David A. Clark School of Law. I don't take it as a defeat because the minute you interpret any of the significant changes that occur from the courts or from other developments in policy as defeats, then you're defeated. In my view, this was a decision, as you said, that invited Congress to issue a new remedy. That's what we do. I'm a lobbyist and lawyer, and that's why I've trained for this role. And I'm very confident that Congress will respond to the challenge of the court to develop a new formula that will help to replace the now overturned formula of the Shelby case, Section 4, with a new standard that will allow the act to be reinvigorated and to be enforced. First of all, there is a record that shows that indeed there is discrimination that exists in the polling place, and we can marshal that evidence and we can contemporize it and we can show that there needs to be a remedy. Secondly, we believe that Congress has the power under the 15th Amendment of the Constitution. Now, it is not necessarily a power that this court was prepared to respect, but we can confront the court in a systematic way, a sort of Houstonian school of jurisprudence, taking a systematic approach to bringing cases that create the inescapable conclusion that the Constitution is intended to do the right thing. So I'm very confident that Congress will do it, and I think we have a political approach that makes sense. First of all, we have a living icon in our midst, and that's John Lewis. The congressman from Georgia is the moral center of an effort to restore voting rights in America. John Lewis, more than any other member of Congress in either house, is really the moral conscience of Congress and arguably the country around issues of voting rights. So whatever we do is in all likelihood going to be named the John Lewis Voting Rights Act, because invoking his iconic status, well-deserved status, moral center, is what ultimately will give us the power to seek change in Congress. And then I think a creation of a coalition. We have a coalition long-standing. That's what the Leadership Conference does, over 200 national organizations. But the coalition that I'm talking about is the coalition of the moral social change, the coalition whose spirit really helped give the March on Washington such grand stature, and that really served as the catalyst for change in the passage of the Civil Rights Act of '64 and the Voting Rights Act of '65. That coalition still exists, and it needs to be rekindled and reinvigorated and brought to bear in Congress to encourage that kind of change, and I think we will do so. Let's go more deeply. Look, first of all, one of the reasons I think that the Shelby County decision was so sinister and so incredibly manipulative is because with the cover of sort of constitutional necessity, which is what Roberts used to strike down Section 4, there was also a belief that, yes, we encourage you to go back to Congress, but we recognize how futile that really is. This is, after all, a Congress that couldn't pass a farm bill. This is a Congress that voluntarily allowed America's economic status in the world to be downgraded over a debt ceiling debate that has been handled routinely in the past and should have been handled routinely here. So Roberts was sort of saying with a wink and nod, please go back to Congress, correct the problem if you can. Okay. I think that as cynical as it was, I think that it's actually quite possible to change the outcome of the Shelby County decision with congressional action, and to do it in relatively speaking, relatively recent terms. I don't think it's going to take us till the next presidential election to find a solution to this. I think that the votes that occurred in the 2006 reauthorization of the Voting Rights Act show strong bipartisan support. Number two, I think that the Congress has to be approached in a systematic way. They have yet to feel our love. I think the idea of how we explain the importance of this bill will help to determine the outcome in the passage of a new law. And then thirdly, I think that my experience with the American people over 30 years as a lawyer and lobbyist has been that when confronted with empirical data that shows that there is a problem, and when that problem is framed in terms that highlight the democratic principles at risk, that the American people support change. Think about the sweep of change that has occurred in Americans' attitudes toward the lesbian, gay, bisexual, transgender community. In a matter of about 10 years, we have gone from a country that wouldn't pass a federal hate crime statute because it had a provision that included the LGBT community, to a country on the border, the verge of allowing marriage equality for same-sex couples. That is a sweeping change, and it has taken less than 10 years to get there. Now, don't get me wrong, it didn't just happen because Americans woke up and realized, oh God, aren't they wonderful, let's go ahead and make this change. It happened because people organized, agitated, challenged the system in a variety of different ways, and refused to take no for an answer. And that same spirit of, the moral center must hold is what's compelling us now to go back to Congress to repeal Section 4. I'm pretty optimistic. Well, let me say, first of all, the Earl Warren Court, which was the court that we largely refer to as the court that helped give us the profound social change that we seek to preserve today, was itself an unusual period in time. The Supreme Court has never been as liberal as its detractors would suggest, and that the struggle to achieve progressive change has always been done against the backdrop of, a conservative cultural unwillingness to accept that change. So in that sense, it's not new. Secondly, the ebb and flow of power in our country sometimes goes to the executive branch, sometimes to Congress, sometimes to the court. Lyndon Johnson was considered a strong executive who could really bring about change because of the power of his personality and his approach to using power. So when you read the John Caro volumes about Lyndon Johnson's role both in the Senate and subsequently in the White House, you get a sense of really what presidential power can do. Congress is now in the position of being asked to respond to these Supreme Court decisions. And our view is, of course, it matters elections count. It always matters who's in charge. I'd be foolish to say otherwise. But I will also tell you that who is in charge does not determine the outcome of the great moral issues of our time. Those are determined, the outcome of those issues is determined by the advocacy of ordinary people who have made their voices heard and who insist that change can be accomplished within a democratic framework. That's the power. It's the power of this country. That's part of what makes America great. The framework permits change even when those who are at the helm of change would resist. So no, it's not that I'm naive, and it's not that I have a sort of Pollyanna-ish view of how politics in America works. It is because I have seen in my own life the power of change brought about in a democratic system where, yes, pressure has been brought and there have been struggles and there have been riots in the street, and what's happening now in Egypt, we have seen variations of in our own country. The question is, how does the power of the democratic institutions, how do they respond to this change? And from my perspective, I'm pretty optimistic that the American people will see the harm done by the Supreme Court and will want to rectify it, and the political system will help to encourage that and to accommodate that change. I do. And keep in mind, that this country today is more diverse. There is a more diverse spread of power than ever before. Now, money distorts politics, and I'm deeply troubled by decisions of the Supreme Court, Citizens United, that have allowed money to be invested heavily in politics. And it won't change until money is taken out of the system. But having said that, we work with the system we have. I'm Rumsfeldian in my view about how the system works. You work with the army that you have, not the army that you'd like to have. And so we're going to make change with the leadership and structure that